Breaking news. The Enhanced Games organization, a controversial and unconventional sports movement that openly allows and even encourages the use of performance-enhancing drugs as part of a philosophy of redefining athletic competition, has filed an unprecedented $800 million antitrust lawsuit against World Aquatics, USA Swimming, and the World Anti-Doping Agency, WADA, accusing these global governing bodies of deliberately conspiring to undermine the legitimacy of its events, block athlete participation, discourage sponsorships, and maintain a monopoly over international competitive sports. And the case is already drawing enormous attention from legal experts, sports analysts, athletes, and the general public because it challenges a long-standing foundation of modern athletics, which has been built for decades on the principle of anti-doping regulations, fairness, and natural competition. Yet the Enhanced Games has come forward with a radically different vision, one that argues that technological progress, medical science, and freedom of choice should be embraced in sports instead of restricted, with its founder Dr. Aaron D'Souza insisting that the current doping bans are outdated, hypocritical, and driven not by athlete safety but by institutional control, corporate interests, and the desire of major federations to maintain their dominance over the sports economy. And in the lawsuit filed in U.S. courts, the Enhanced Games legal team alleges that athletes who have expressed interest in joining their competitions have been intimidated, threatened with permanent bans from the Olympics or World Championships, and cut off from funding or sponsorship deals, which, according to them, amounts to a systematic violation of antitrust law and an abuse of regulatory power. Since the Enhanced Games claims to provide a legitimate alternative sporting platform where competitors can push human limits beyond what is possible in drug-tested environments effectively, pitting natural performance against enhanced performance, and the organizers further argue that the hypocrisy of current sporting federations is evident in the fact that many athletes already use legal supplements, advanced therapies, and recovery techniques that blur the line between natural and enhanced performance, while others secretly dope despite bans, creating an uneven playing field. So their philosophy is to allow everything in the open under medical supervision, thereby ensuring transparency, safety, and record-breaking results. And in this sense, they compare themselves to how mixed martial arts was once dismissed as brutal and fringe but eventually became mainstream, suggesting that their vision of science-based sports could one day reshape the Olympic landscape, though the lawsuit itself focuses primarily on antitrust law rather than ideology, accusing World Aquatics and USA Swimming of using their financial power and international influence to blacklist Enhanced Games events, pressuring broadcasters not to air them, warning sponsors of reputational damage if they sign contracts, and lobbying governments to reject licenses or visas for athletes intending to compete, all of which, according to Enhanced Games' legal complaint, constitute a coordinated effort to strangle a new competitor before it can establish itself, and this, they argue, violates U.S. antitrust laws designed to promote market competition and prevent monopolistic practices. And the requested damages of $800 million reflect both actual financial harm and projected losses from events they say were sabotaged, though legal experts warn that proving conspiracy at this scale will be extremely challenging, especially against institutions like WADA that operate under international agreements. But the May filing of such a lawsuit is already being described as a watershed moment in sports law because it forces courts to consider whether sports governing bodies have too much unchecked power, with some commentators even likening it to earlier legal battles in boxing, football, and cricket where breakaway leagues tried to challenge traditional federations. And at the center of this debate are the athletes themselves, many of whom remain divided, as some see the Enhanced Games as a dangerous experiment that risks normalizing drug abuse, while others, especially former athletes who face bans, see it as a liberating opportunity to compete without hypocrisy. And already, a handful of Olympic medalists and retired champions have quietly expressed interest, though most remain anonymous for fear of backlash, and the public reaction has been equally polarized, with critics condemning the Enhanced Games as reckless and immoral, accusing it of turning sports into a science experiment that undermines human integrity, while supporters argue that progress has always come from pushing boundaries and that society already accepts performance enhancements in other fields, such as medicine, education, and technology. So why not sports? And the lawsuit now forces a deeper confrontation between these philosophies, with court hearings expected to last months if not years. While in the meantime, the Enhanced Games continues to plan its inaugural event, promising million-dollar prize pools, global streaming rights, and the shattering of long-standing world records under conditions of full transparency. And if the lawsuit succeeds, it could open the floodgates for alternative sporting federations to challenge the dominance of institutions like the International Olympic Committee, reshaping the economics and ethics of global sports forever. But if it fails, it could cement the authority of anti-doping agencies for decades to come, effectively killing the enhanced games before it fully begins, making this case not just about $800 million in damages, but about the very future of how humanity defines sport, fairness, competition, and the role of science in pushing human limits.